risks and rewards of real estate. So as mentioned, I'm going to be your presenter. My name is Melanie Griswold. And before we get into the meat of the presentation, I just wanted to take a moment to introduce myself. So as mentioned, I've been a lawyer for the last 17 years and a real estate broker for the last 3. I've had a wide variety of legal experiences, which, as it turns out, has been incredibly beneficial to my real estate practice because there are so many different issues that can come up in real estate, from landlord-tenant issues, more typical transactional issues like contract drafting, finance, construction and permitting issues, and of course, we all want to avoid, which is litigation. So before forming SALA Homes and Real Estate at Hestia Real Estate with my amazing team of Sunny, Stephanie, Abby, and Lisa, I was a real estate fraud prosecutor for Santa Clara County, where I investigated and prosecuted various real estate scams. So unfortunately, I've seen many examples of deals that have gone bad. But over the next 45 minutes or so, I want to cover some of the major issues that I see from my perspective as an attorney, answer some of the questions that we have received in advance, and then hopefully leave you armed with some more knowledge and some tools and tips to ensure that your transactions go smoothly and you can reap the great rewards that come from owning and investing in real estate. So following up on my theme of the good, the bad, and ugly, let's start with the good. Start with the positives. So real estate investments, as many of you know, I'm sure, believe you're tuned into this webinar, it's one of the fastest and safest ways to build wealth and grow your net worth in this country. 90% of all millionaires became so through owning real estate, and the benefits are numerous. You have passive cash flow, huge tax saving opportunities, leveraged appreciation, especially right now where the interest rates are so low. And as your principal is paid down, the cash flow only increases. Also, you can use your real estate equity to secure new sources of financing and continue building wealth. In Santa Clara County, it has been a particularly good time to invest in real estate. We see that in September of 2020, that the sales of single-family resale homes are up 33% from last year, and that sales are up 11% compared to even last August. We see that the median sales price for single-family homes is up an astonishing almost 15% compared to last year, and that the average sales price is up even more than that. But it hasn't just been the last year that's been good for Santa Clara County or real estate in general. We see that since 2016, the single-family home price has gone from $1 million in 2016 to almost $1.4 million in the third quarter of 2020. We see that the median condo sales price has gone up from $585,000 in 2016 to $715,000 in 2020. So almost a 40% jump in 4 years for single-family homes, and a 22% increase in value since for the condos. So does that mean that every transaction is going to make you wealthy, or even or that you won't lose money or buy into a big problem? Well, of course not. The bad part of real estate is that while there are great risks, there are great rewards, there's also great risks. And no presentation about real estate would be complete without acknowledging that there is risk in real estate, and as there is in any investment, and given the amount of money that is at stake in real estate, when a transaction goes wrong, we can easily be talking about tens of thousands, if not hundreds of thousands of dollars that can be lost. Now, of course, there's plenty of risk that we, I think, are all aware of, from market shifts, interest rates, more recently, the impact of COVID on tenants. We also have new legislation. There's rent control, eviction moratoriums. But the ugly truth of real estate is that you cannot always trust everything that you see, and that we really need to be aware of what we don't know. In real estate, ignorance is definitely not bliss. Not all issues are going to be apparent to the buyer. That beautiful new kitchen may have been done without permits. The foundation may be falling apart. Termites may have eaten through your structural supports, and the seller might not even own the property, or someone else might have a claim to it. And the reality is that not every seller will be as forthcoming as they should. They might not be aware of the problem, or they may think that if they disclose it, they'll get less money. The good news is that much of this risk and the risk that I discussed can be controlled through proper planning for the worst case scenario, carrying an appropriate amount of leverage, and having an adequate reserve so that you're never in the position of having to sell when the timing is not right. The other good news is that knowledge is definitely power in the realm of real estate. So once we understand the risks of real estate, then we can manage them. So what is the number one risk in a real estate transaction and the surest way to find yourself in the midst of an entirely preventable, very messy deal gone wrong? Well, some of you may have guessed, it is disclosures. It's the breach of duty of good faith and fair dealing, which is read into every real estate transaction, but does not necessarily occur. The failure to disclose poses both a huge risk on the seller side, as well as a huge risk on the buyer side of not knowing what you're truly getting. So let's talk about disclosures. What needs to be disclosed in a real estate transaction? Well, the state and local jurisdictions have mandated disclosures, and there's some things like smoke detectors, lead paint, water conserving fixtures that are standard disclosures that need to be made. There's also a rule that we need to disclose anything that is material to a transaction. So what is material? Well, material has a very specific meaning in the law, but it is also one that is common sense. Basically, what it means is it's an important factor on the desirability or value of the property. That is something that is material to the transaction. So some common examples would be foundations, unpermitted work, neighbor disputes, significant noise issues, such as an airport or a nearby daycare, pest problems, perhaps the fact that someone died recently at the property, or even such things as maybe really low water pressure. And I tried to think of some examples that were not material, and frankly, I struggled in that because often materiality is in the eye of the beholder, and most things in a real estate transaction are going to have some sort of effect on the value. And so we will, and as I'm going to go through in the presentation, we'll definitely want to err on the side of over disclosing rather than under disclosing. But some things that might be immaterial would be nail holes in the walls that can be fixed fairly easily, or something like landscaping, which turns out to be really time intensive, but that's pretty obvious. So you might be asking yourself, well, is there a legal difference between lying and just not saying something when it comes to disclosures? Well, in the law, there can be a failure to disclose both with a misrepresentation as well as with an omission. So misrepresentation is considered when we say something that is untrue or incorrect. An omission is when we just leave it out. But in the law, that is read to say that we're actually representing a non-existence of that fact. So an omission might feel different than an outright lie, but the reality is that they're both problematic in real estate transactions. And while the misrepresentation is definitely more so than an omission, but simply not saying something, especially if you're actually aware of the issue, is not going to save the transaction or the seller. You might also be asking, does it matter whether the omission or misrepresentation was intentional versus unintentional? Well, the short answer is yes and no. So when there is an undisclosed material fact, meaning something that has a significant and measurable effect on the market value of the property, just as an accident requires a car to be fixed, regardless of whether one person was at fault or not, the issue may lead to liability regardless of whether there was an innocent mistake or an intentional lie. So let's unpack what that means. For a misrepresentation, this is something where we have stated something that is not true. You can have liability whether it's intentional or unintentional. So the three ways that you can be liable as a seller are if you have actual knowledge, so that would be an intentional misrepresentation typically, or where you're recklessly representing something without regard for the truth. So you make no effort, for example, to verify what the square footage of a particular property is. You just take a guess at it and you put that into your listing. Or you have no reasonable basis to believe the facts are true when saying them. For an omission, the basis for liability is a little bit more limited. If you have actual knowledge of the facts and you don't state them, then you're likely to be liable. Or if the material facts are accessible to the seller only, and the seller knows that they're not easily discovered by a buyer who's exercising a diligent investigation, then the seller is going to be bound to disclose those facts. So not disclosing them, even if it was unintentional, is still going to subject the seller to liability. Now, liability also requires other aspects in addition to having the omission of representation. So as we've discussed, it requires materiality, meaning that it's important. It requires damages, meaning that there's some sort of fix that needs to be made, some sort of damage to the buyer. And then it also requires a reasonable reliance on the misrepresentation. So with the misrepresentation, when you have an actual affirmative statement that is not true, it's going to be very difficult to argue that the buyer's reliance on that statement was not reasonable. Because if you as a seller didn't want the buyer to rely on it, then why did you say it? And the same thing is going to be true for an intentional omission. If it can be shown that the seller willfully omitted something that they're obligated to disclose, then the obvious implication of that is that they were trying to hide something and the intent was to keep those facts from the buyer. And the only reasonable conclusion from that is that the buyer would have relied on those representations, and that's why the seller was trying to hide it. The gray area comes from where there's an innocent omission. In this case, the seller may not be aware of the facts and they don't disclose them. And in this case, the liability will depend on whether the issue could have been found through a diligent and competent inspection or not. If the inspections are done by the seller or a competent third-party professional, so you get a pest inspector to come in, you do a roof inspection, or you do a foundation inspection, then it's going to be really difficult to put any liability on the seller for the non-disclosure. If the issue was missed by a professional, how would you expect a layperson, which typically the seller is, to find it? If the buyer waives inspections and the inspections likely would have found the issue, then you also have the situation where some responsibility will likely be placed on the buyer. But it'll turn on the language in the contract and the advisories that were signed in terms of whether the buyer waived the inspections, whether they had the right to do inspections, whether they had adequate time to do the inspections, whether they were advised that it would be a very good idea to do inspections. So as we see in the Bay Area, with a really hot market, we have as-is sales. And many people commonly think of this as being an out to having an obligation to disclose, or as preventing the buyer from coming back and suing the seller. And the reality is that the as-is clause does not typically save the seller from liability, nor does it prevent the buyer from going back to the seller. When you have an intentional misrepresentation, the as-is clause is basically going to be worthless, because the buyer's failure to investigate, taking it as is never going to be a defense to an intentional or negligent misrepresentation. And basically what the as-is sale does is it almost guarantees reliance on the misrepresentation. So sort of an ironic situation, because many people think this actually protects them, but in reality, it actually may hurt, at least where there is a misrepresentation. And sometimes those misrepresentations may be simply that the seller is making an honest mistake, though a careless mistake. Where it does offer some protection is in the area of an omission, and that goes back to what I was just talking about with the buyer having some obligation to undertake investigations typically. And if the buyer doesn't undertake those investigations, then the as-is sale, coupled with advisories that it's important to do the inspections, may in fact relieve the seller of liability in those circumstances. Although, as I often say, a cure is worse often than preventing the problem. So if the problem could have been prevented through inspections that would have revealed the issue, it puts everybody in a much better position than trying to sort through these issues afterwards. So some other common legal issues, obviously the biggest one being really the non-disclosure, is you have bait and switch. I'm sorry, I advanced too far. Is bait and switch, and you have unqualified buyers. So how this comes up in a transaction is not so much that there's a legal issue, although sometimes it affects the deposits, but it's really where the deal doesn't go through. So the buyer may represent themselves to be far more qualified than they actually are. And then it turns out that they can't close the deal, and then you have an issue about the deposit, which I'm going to address in a little bit. Another issue that I often see is poor drafting of contracts. So where you have terms that are ambiguous, they're contradictory to other terms in the contract, or they contradict representations that were made verbally, and where that comes up later on, and there's arguments over that. So a good contract is one that is clear. A good contract is one where everybody knows exactly what is happening, when it's happening, and whose responsibility it is. Another legal issue, I don't see this that often in my role as a broker, but I did see this a lot in my role as a real estate fraud prosecutor, where there were private party transactions. So we had situations where folks were investing in different transactions. They thought they were buying into a particular deal. It was outside of escrow, and there was really no oversight to that transaction. And unless the buyers or investors were really sophisticated, they were often tricked by unscrupulous sellers. The other issue that comes up a lot is tenant-occupied properties. So tenants come with a whole host of issues and benefits. Obviously, I think that owning investment properties is a great way to build wealth, and that requires having tenants. And so tenants are very much your bread and butter, but they're also at times a problem that needs to be managed. And when you purchase a property that has a tenant already in it, much care needs to be brought to the deal to ensure that you're not purchasing a problem. We also see new construction remodeling defects, so that goes to the work not being done in an appropriate manner, or where the work simply wasn't done with permits, so that there's some sort of issue that comes up with it, which may or may not be obvious when you're actually purchasing the property. And then lastly, there are title issues. And so title issues are often avoided by using an escrow officer, getting a preliminary title report. But it may be that there's some issues in behind the scenes of where the seller, there's other people that have claims to the property, the title, the seller may not have good title to be able to convey to the buyer. So that issue can also come up. So before we started the presentation, some folks emailed some questions that they were interested in, some legal questions. So I'm going to endeavor to answer some of the commonly asked questions that came in. So one of them was, everything was fine until the deal closed. Now what do I do? So the deal is done and the property is closed, and then something comes out afterwards. What's going to happen? Well, there are two ways that it can go. One of which is that the seller gets sued for a breach of contract, and the other is that the buyer seeks either damages or to rescind, meaning to basically unwind the contract. The buyer can choose to keep the property and sue for damages, or the buyer typically can try to unwind the deal. Sometimes another party might also try and unwind the deal from the sale side as well. So that happens. Maybe there is an undisclosed person who has claim to the property and the property was sold without their knowledge. They may also have a claim of where they're trying to take the property back from the new buyer. So whether a deal can be rescinded very much depends on how soon after the deal has been closed and whether the buyer or the true owner acted with appropriate diligence. So courts are going to be more reluctant to actually totally unwind the deal unless it can be shown that you're coming in with clean hands, meaning you're really innocent in the deal. You've sort of done everything you could, and you find yourself in this situation of where you either should not be the property owner because you purchased something that was totally different than what was represented to you, or you're the true owner and your property was sold to a buyer, but you actually have claim to that property. Most often, you're going to find yourself in a situation where a deal has gone wrong, where there's going to be damages that are sought, some sort of compensation for whatever harm was visited to the other party from the transaction. So question number 2. So your deal blew up, the deal didn't close. What happens to the deposit? So this is a very common area of confusion. And the law in California is that deposits are never non-refundable. And generally, liquidated damages, which is a predetermined amount of money that will be forfeited in the event of a breach, are often disfavored. So the law does not favor enforcement of liquidated damages clauses, and deposits are never considered non-refundable. So many people think that the deposits are automatically non-refundable once you're outside of the contingency period, and that is actually not true. But in real estate, liquidated damages clauses may be enforceable, and most CAR contracts, so the California Association of Realtor Contracts, which is the standard contract that is used and I would recommend should be used because it's been vetted by great attorneys who have worked through these issues, it does have a liquidated damages clause. So that liquidated damages provision needs to be initialed in order for the deposit to become non-refundable. So the deposit actually never becomes non-refundable. It's simply that the liquidated damages becomes equal to the deposit. So a way to make that non-enforceable would be to make your deposit more than what is considered reasonable. So in California, a liquidated damages provision that's 3% of a residential sale price is typically seen as a reasonable approximation of the damages that would result if a deal were to fall through. Now, if you don't have a liquidated damages provision that is initialed, the deal falls through, it doesn't mean that the seller can't go after the buyer for some damages. What it does mean, though, is that the seller is not entitled to have that deposit go to them first before the issue is determined by the court. If there is a dispute about the deposit or the liquidated damages clause, you should also know that the escrow company may end up holding on to that deposit because they do not want to be liable for giving it to the wrong party. So it may be that the liquidated damages amounts are simply held in escrow while this is worked out. But if you do have a properly initialed liquidated damages provision that says all of the right things in the font that's required, meets all of the technical requirements, then in real estate, it is one of the exceptions to the rule in California, and you can get liquidated damages. So one of the questions we also received were, how are real estate conflicts settled? So of course, there's formal and informal ways to settle real estate conflicts. As a lawyer, I would say that the best way to settle conflicts is through good communication, prevention, and being reasonable. But sometimes this doesn't work, and we have both some range of formal ways to settle the disputes. So realtor associations offer mediation opportunities for both sides to work with an experienced neutral. So a mediation is different from other ways of settling things because a mediator is going to be somebody who's experienced and neutral, and they're going to hear the facts, but they're going to not be able to force the parties to come to any sort of settlement. And they're also not going to make any decision one way or the other. They're going to make non-binding recommendations that the parties can ideally take into account in reaching their own settlement. In many deals and in the CAR forms, you also have a place to opt for arbitration. So this is a more formal process, but it's private. So in an arbitration, the parties will choose a neutral, experienced person, pay that person, and the arbitrator will decide the case. Typically, it's much faster and less formal than going through court, but at the end of the day, the decision will be like a court order in that it's an enforceable judgment. And then the last option is that you have the courts. And here, the state is going to provide the judge, and the case is going to be a matter of public record, and it's going to work itself through the system. Typically, it's more expensive on the part that you have to typically engage a lawyer. You would be well served to engage a lawyer in most lawsuits, but you don't have to pay the arbitrator, but it does typically take a lot longer. So an average case might take 2 to 3 years to come to a conclusion, whereas with arbitration, you could be looking at a decision in 6 to 12 months. So question number 4. So I got less than I thought I was getting. What do I do? So this is where you've closed the transaction, and this is similar to my answer for the first question that came up. So this happens with boundary disputes, square footage representations, and other issues like that that can come up. So the remedy for the buyer will depend on whether the issue was a misrepresentation or omission, as we discussed, and whether there's liability on the part of the seller. So if there is liability, because maybe there's an actual misrepresentation or a reckless misrepresentation or an actual omission, then the remedies are going to be what we talked about, basically damages or rescission. But if there's no liability for the seller, in not all situations can you go back to the seller. Perhaps this is a situation where the seller advised that this is the square footage per county records, and it turns out that the county records are wrong, or the buyer was advised to go and investigate and they didn't do any investigation, then the buyer may not be able to go back to the seller. And then in this case, it may just be that you bought what you bought and you have to live with what you bought. Some of these issues you have a right of action against perhaps the neighbor. So if you have a boundary dispute and there's a fence that's encroaching on your property, then you might not be able to go back to the seller, but you may be able to go to the neighbor and seek some sort of remedy, whether that's through a court action or through a private settlement where you work those issues out. But that's basically what happens is if you don't have the seller to look to, then it's going to be whomever is causing the issue, or if the issue is simply there and there's nobody to look to, then you probably stuck with it. And so my tenants and neighbors are nightmares. What are my options? And so again, the answer to this question depends on whether the seller knew about the issue or not, and what level of investigation was done by the buyer. So assuming that the problem was not known by the seller, then the buyer has, for lack of a better term, really bought the problem, and they must deal with it as he or she sees fit, either getting a lawyer or working out the problem informally, which is why it's very, very important, especially with tenants, to undertake the appropriate investigations before buying the property. And with neighbors, it's important to actually put your eyes on the property, see what's there, because one thing to look at what something is on paper. It's another thing when you notice that, for example, there is a daycare right next to you that's going to be noisy, and that might not be obvious just from the paperwork that was provided. So we've gone over the good, the bad, the ugly. Well, there is great opportunity in real estate, and because the risk here really comes from not knowing what you are doing. And the good news is that a lot of risk can be mitigated by knowledge and by doing exactly what you're doing here, which is listening to this presentation and becoming more educated. The other good news is that unless you really want to sell your property as a for sale by owner, or unless you opt for a private transaction outside of escrow, or you buy a property without a real estate agent, you're not alone, and you can leverage the experience and knowledge of your agent, your inspectors, your escrow and title officer to greatly reduce the likelihood of problems arising down the road. So what are some of the benefits of working with a professional? Well, the commonly understood ones relate to marketing, pricing, and negotiations. Agents are in the business of buying and selling, and they should know the neighborhood, know the market, and be able to both help you position your property in the best light possible if you're selling through staging and the like, but also help you see through the window dressing of a home that's just been prettied up but may have some other issues. Some other benefits that are less obvious, but perhaps even more important, are that an experienced agent has a better sense of when to dig deeper. For example, a buyer might present an all-cash offer, which seems great, but the proof of the funds might be doctored, or there needs to be more investigation and diligence into that buyer. And the buyer and the agent may be able to evaluate whether, for example, a contingency for the sale of the buyer's home represents a real risk of the deal falling through or not. Just having that experience, the benefit of having seen a lot of deals, having seen where they go wrong, where that agent can really advise you on the risk. The other way in which having an agent helps, particularly where the seller is represented by an agent, is that they can help spot common title and family dynamic issues. If you have an agent representing a seller, they need to have a listing agreement. And in order for that listing agreement to be valid and for the agent to be paid, they need to have the authority to be able to sell the property. So the agent has perhaps as much incentive as the buyer to ensure that that owner truly has the authority to be entering into the listing agreement, and the agent will be doing some of the vetting on the title issues. The agent probably also has more insight into what the family dynamics is, and they may have the opportunity to have a better understanding of what's happening behind the scenes there, so that they can head off some of the issues that might come up with seller's remorse or family members that disagree with the home that was passed down to the heirs being sold, and those sorts of things. Most importantly, they really can head off costly legal mistakes by drafting clear contracts. So agents are not technically supposed to draft any contracts, but many agents, and certainly with our firm, we have the benefit of in-house legal counsel. We'll go over those provisions to ensure that you're getting a clear contract in your transaction, and that's going to prevent a lot of misunderstanding and issues that come up. The other aspect is that agents, because they know the rules and how strict the laws are on disclosures, I think agents are going to encourage reluctant sellers to disclose. They're going to be that second set of eyes, because in any transaction, agents also have duties of disclosure, and then they're also going to order the appropriate inspections that are needed. So one of the great ways to protect yourself is to ensure that you have inspections done on the property, and that's going to be a huge benefit, because as we discussed before, if a third-party professional has missed it, then that really is going to relieve a lot of liability from the seller for a missed disclosure. And the same thing, that as a buyer, you're not being totally reliant on what you can see, but you're getting people who know what a foundation should look like, who know whether there's any cracks in that, who are going to be telling you what the true condition of a home is. The SALA Homes and Hestia Real Estate, we offer all of these services. So the SALA Homes team has the market expertise, can do the staging and presentation. They have off-market listings, which are really beneficial in today's market where it's so competitive. The construction and remodeling experience, which helps being able to evaluate when you go into a house and the quality of the remodel, and whether it was simply a flip or there was real attention and detail paid to that remodel. And finally, we have the in-house legal counsel. On the Hestia real estate side, and that's the side that I focus more on, my role is more in the tenant and property management side, land use consultation, redevelopment opportunities, and of course the in-house legal counsel. So I hope that you found this presentation to be useful. We're here to help. My contact information is here if you have any questions. There's things that I haven't answered, or you have some other questions that have come up that you want to have answered. We're here to help and would love to be of service to you. And that concludes my presentation. Thank you.
Thank you so much, Melanie. Does anyone have any questions they would like to ask? Feel free to enter it into the chat below.
In the chat below.
Sure. No.
May I ask a question now or I
Yes,
have?
you can ask right now too. Yes.
Hi, first, my name is Jonathan. Thank you very much for the great presentation. I have a case. I recently sold a house and the seller, I'm the seller, the buyer is suing us for not disclosing a problem with the floor. And the buyer is asking for 110K for the floor. And they have done the inspection and there's no problem found in the inspection. I just wonder what's the suggestion for us and what's the best and worst situation, scenario for us?
So the good news is that you did an inspection. So that's going to really relieve a lot of potential liability for you. And then the other aspect is I'm not sure what your property is or how big the area is, but 110,000 seems like a really big claim for flooring. So unfortunately, with litigation, you don't always have a choice of whether you're going to be a defendant in a lawsuit. You have a choice of whether you're going to be a plaintiff, meaning that you're going to file the lawsuit, but you don't have that choice in terms of whether you are going to be a defendant. So have you actually been sued where the lawsuit has been filed?
Not yet. We are going through the mitigation.
Yeah, the mediation part of it.
Right. This is the house we just remodeled. We never live in there, and there is a builder. And the builder originally agreed to fix the problem areas, but the buyers insist to replace all floors. It's about 24, the house is 2,400 square feet. And but eventually, the builder agreed to replace the whole area, but the buyer weren't happy. They want more money, so including with the 100,000, they include like 24K for painting and 20K for Airbnb and like 10K for moving.
So I guess there's two parts of it. One is whether you have any liability at all, and you may not have any liability for the problem if you didn't know about it and it wasn't obvious through an inspection. So this may be something where the buyer actually, their right is to go against the builder. So that's one way of looking at it. So, and then the other part of it is that the amount of damages that are being claimed sound like they're unreasonable. So your builder and you, it would probably be worth getting alternative estimates that show that the true damages are much less. But if this is also something, if you would like me to help you in any way, I'm happy to take a look at your case.
Sure, we definitely will go to you if anything else arises. I will take note of your contact information. We appreciate your help here. Thank you so much.
You're welcome.
Thank you very much.
Yeah, we'll contact you later. Yeah.
Hi, Melanie. Someone in the chat said, do you also provide legal counsel against a design firm / architect?
I can. I work with a lot of architects and design firms in my development work, but at the end of the day, if somebody has not done a good job, then yes, it's as a lawyer, I will look at the facts and evaluate and try and give you advice about whether you have a good claim or a bad claim, and I'm happy to help with those things.
Thank you so much. Sajal in the chat said, "Hi, we bought a house 2 years ago. When doing addition this year, we found the wood frame and one original exterior wall near bathroom are water damaged and broken already. Is it okay to contact previous seller agent to get some credits back?"
Well, it's always okay to try. Whether you're successful or not is going to depend on what that contract looked like and what the inspections were like at the time. So this will go to trying to unpack whether the seller of the property from 2 years ago knew about this damage and concealed it, or whether they did not know about it. And then in this situation, so I mean, with water damage, it's not always possible to determine, but it may be obvious whether it was relatively recent or whether it was a really old situation. If the seller or what the sort of source of water damage was. If you can have a slow leak where the seller might never know about it, or you could have a flood where the seller definitely knew about it. So it's pretty probably fact dependent on the situation. But the rule in terms of the timing is usually that you have a cause of action or claim that runs from the time of discovery of when you either discovered it or when you should have discovered it. And so if it's like something that is not discoverable unless you rip up your house, then you probably have a pretty good claim for a delayed discovery cause of action. But whether you have a good cause of action or not depends on the contract and the particular circumstances.
Thank you. Can you explain to everyone the procedure if we found some problems with the house which does not match with the disclosure?
Well, it's very fact dependent. So if it is, let's say it is a square footage issue. So if the square footage is stated and it's disclosed that the square footage comes from county records, let's say, and the county records in fact show a particular square footage that turns out to be wrong, then there's probably no claim against the seller as long as they said that it came from county records and advise the buyer to verify. If they did not make that advisement, or they did not qualify where it came from, then you might be able to look back to the seller. So it really depends on the situation and where the problem is, whether it's something that's obvious or that is more, you wouldn't necessarily expect the seller to know.
Okay, thank you for that. If anyone has any other question, please feel free to unmute yourself or type into the chat. While we're waiting, Melanie, can you please explain the main difference between arbitration and mediation?
Yeah, sure. So basically, mediation is going to be a voluntary, both of them are voluntary processes. But a mediation is non-binding, meaning at the end of it, if the mediator makes recommendations and one side doesn't want to follow those recommendations, then you both go your various ways, and then you have to resolve your case through a different way, either the court or an arbitration. In an arbitration, you're actually going to get a binding decision, meaning that whatever the arbitration decides is going to be, one side is going to be, well, both sides are going to be bound by it. So one side is going to lose and the other side is going to win.
Okay, thank you so much. A lot of our clients always ask about non-contingency offers and how to get deposits back. Do you think you can explain a little bit about that?
Meaning that as buyers, they do a non-contingency offer and they want to get their deposit back?
Yes.
Okay, so if the liquidated damages provision is not signed or initialed, then the deposit is by law refundable. But the caveat to that is that the seller could still seek damages against the buyer in that circumstance. But the practical reality is that it's costly to, to proceed with the litigation, and it might be easier for the seller to simply get into contract with somebody else. And unless the property sells for less money, or there's some sort of damage to the seller, then they're not going to be able to prove damages. So, the seller, to be able to recover from the buyer, is going to have to show that they in fact incurred damages. But in a rising market like what we have now, the seller probably is going to be able to turn around and sell the property for more money to somebody else. So practically, as long as you don't sign that liquidated damages provision, there may not be that much risk to the buyer from losing their deposit, but they should still appreciate that there is some risk.
Thank you. Dan from the chat asked, "Hi Melanie, when a lawsuit is filed, who pays the legal fee? Is it paid at the end of the lawsuit then, or at the start upon engaging the legal services of your firm?"
So the who pays is, the general rule is that each side pays their own fees. So in most civil lawsuits, each side is on the hook for their own legal fees. At the end of a lawsuit, the cost may be transferred to one side or another, and those costs include things like expert witnesses or court reporters, those sorts of things, but they don't typically include attorney's fees. Some contracts will actually contain language that makes the losing party responsible for reasonable attorney's fees. So you do see that in a lot of contracts, but until the case is ultimately decided, either by a court or an arbitrator, you'll see most sides bearing their own cost in the matter. There's some exception to that, but that's the general rule.
Mm-hmm. Thank you. Angel in chat asked, "I have bought a house 1 year ago. The appraisal report has the same square footage as the seller stated, but this year when I did the refinance, the new appraisal report square footage is 100 square foot smaller. Can I ask for some credits from the seller?"
So when you have the measurements of homes, there often is some variation in that. There's a saying, if you have 5 architects or surveyors measure a property, you're likely to get 5 different measurements. So, depending on how significant that is, like if you say your property was 600 square feet and it's 100 square feet off, then that might be a pretty significant change in that. But if it's a larger property, that's probably sort of in the range of where if you just make some changes in the measurements, you end up with a different number. So I would say in that circumstance that you do not go back to try and get any compensation. And also, I think typically an appraiser doesn't go out and may not measure the property. So, if you were to go and sell the property, you might want to actually go and have it properly measured to determine what the actual square footage is, because now that you as a owner have 2 different measurements, that would be something that you would want to disclose to any future buyer.
Okay, thank you. B in the chat asked if after under contract buyers discover asbestos and underground oil tank, but the contract says that the repair cannot exceed $500 for seller after signing contract. Anything the buyer can do here? Thanks.
Well, a underground, that kind of contamination. So there are mandated requirements around natural hazard disclosures, and typically that includes some aspect of environmental risk. So if the disclosure there was not appropriate, the buyer may have more options of rescinding the contract once they discover that. You have to look at what the contract actually says in that circumstance. Because it's really more of a disclosure issue versus that your limitation on repair is the 500. I would be looking at it more from was there something that was not disclosed that should have been disclosed, in which case you as the buyer can get out of it, rescind the contract regardless of the limitation on the repair cost. That's the way I'd probably look at it.
Hello. I actually raised that question. The repair writer actually says the Santa, to the best of the Santa's knowledge, there is no asbestos. That's one statement. And there's no statement on the oil tank. But we found that from the county's website, it says the county actually urges all the homeowners to do that because the oil tank is quite old. So any oil tank that's quite old, they urge it to be removed or abandoned.
And was do we know if the seller was ever advised of the oil, like removing the oil tank?
We don't know whether that's required, but maybe we can ask about the asbestos here, because the contract says the seller represents, to the best of their knowledge, there is no asbestos. However, the inspector told us there could be.
So if the seller's representations, like in the SPQ, the seller property questionnaire, are to their knowledge. And so if they don't have knowledge of it, it's not typically a misrepresentation. But like, and especially with asbestos, because I mean, the average person is not going to know whether the material contains asbestos or not. I mean, if it is built before a certain period of time, then many homes actually have asbestos, and most people just don't know about it, or they don't find out about it until they're doing a remodel. But on your oil tank issue, it really turns on whether they know about it or not, because that's such a big thing that that if they had any knowledge of it, it would definitely should have been disclosed.
Thank you.
Welcome.
Okay, question from the chat. I bought a house and the seller remodeled the house and changed the floor before selling. We found bathroom floor leaking and it is not recent leaking. It is not in disclosure and it is not in the inspection since it is covered by the floor. Can I ask the seller to fix it?
Yes, I think that would be a much clearer thing, because you've got, again, with all of this, it is pretty fact intensive, and I'm sort of giving advice without really knowing the full situation or seeing pictures and that sort of thing. But where you have a problem that's being literally covered up by a seller, then you're gonna, as a buyer, have a much better claim, because how are you supposed to know it's there? And if the seller actually covered up the problem, even if it was meant to just do a remodel, but it, practically speaking, it makes it much more difficult for you to find it, then you've got a much better claim against the seller.
Thank you. Question from the chat. What should I do if I have a boundary dispute with my neighbor?
With a boundary dispute with your neighbor, those issues are pretty complicated often, but the first place would be getting your property surveyed by a land surveyor to actually find out where the boundary is. And then likely you would need legal counsel to actually resolve that issue.
Okay, thank you. Question from the chat. I already in contract of selling my house, and the buyer removed contingency already. The city sent a letter to remove the tree and need to pay $2,500, and we can pass the letter to a new owner. Who should pay?
So this is something that needs to be, that the city is requiring to be done.
Yes, yes.
That is a good question. I am not entirely sure, but my instinct on that is probably the seller, because the obligation arose before the sale was closed. So you as seller are still the owner, and so that obligation is your obligation until it passes to the buyer. But I would have to do further research on that.
Okay, thank you. Question from the chat. If I'm in the process of buying a house, can I get the deposit back if I cancel the transactions?
If you are within your contingency period, yes. And if you haven't signed the liquidated damages provision.
Okay, thank you so much. Okay, thank you so much, Melanie, for being here, and we appreciate everyone for coming and to attend our seminar today. I guess this is it for this time. We welcome everyone, if they have any more questions, to contact SALA Homes directly, or you guys can write down the contact of Ms. Melanie Griswold on the page and contact her directly for any further questions. Thank you all for coming.
Thank you, everyone.
Last but not least, please visit our website, www.salahomes.com, or subscribe SALA Homes on YouTube, WeChat, or 小红书. Thank you.